Hello and welcome. This presentation today is intended to teach you things to look for when considering powers of attorney. In this generation today, powers of attorney can be misused and abused by those holding them. And it's important for you to know what to look for in order to be able to protect victims from having those powers of attorney used against them. The subject matter for this presentation today is going to be focusing on Chapter 709 of the Florida statutes. Chapter 709 deals with powers of attorneys and deals with what can and what can't be done with those. During this presentation today, we're going to talk about how powers of attorneys can be created. In looking at that, you need to know what is a power of attorney, what is an agent, what is a principal, and how is the power of attorney created, who may serve as an agent under that power of attorney, and when does a power of attorney become effective, when does it terminate, what does it mean to be durable, and how do you check to see if a power of attorney is in fact durable. What authority does an agent have under a power of attorney? What limitations does an agent have under a power of attorney? And what obligations does an agent have under a power of attorney? And then what liability does an agent have should they abuse their power? And what are the potential remedies and the judicial actions that can be taken to remedy a situation where an agent has abused a power of attorney? So first, let's discuss what is a power of attorney. You will notice during the PowerPoint that down at the bottom of each slide refers to the section of the Florida statute that you can find the information that's being discussed. What is a power of attorney? Under section 709.2102 of the Florida statutes, a power of attorney is a writing that grants authority to an agent to act in place of a principal. Very simply put, it is giving one person the ability to use a power of attorney to act in the place of another. In this situation, an agent is the person who is being granted that authority to act under the power of attorney, and the principal is the person who is giving that power up and giving it to the agent to be able to act in his stead. So how is a power of attorney created? This is important. A power of attorney must be in writing. It must be signed by the principal, and it must be signed by two additional subscribing witnesses, as well as signed and acknowledged by the principal in front of a notary public. So if you're looking at a document, the first thing that you should check is to see whether or not these conditions exist, and whether or not the principal did sign, whether there's two witnesses, and whether or not it in fact bears a notary's signature. Who may serve as an agent? Any person over the age of 18 or a financial institution that has trust powers, has a place of business in the state, and is authorized to conduct trust business in the state. When is the power of attorney effective and when does it terminate? Another important issue to be taking a look at when you are faced with reviewing a power of attorney. The power of attorney becomes effective upon it being validly executed, delivered to the agent, and upon the term of the power of attorney. Now what that means is powers of attorney can dictate the time limitation. It may be for a period of time not to exceed 1 year. Once that 1 year expires from the date that it was executed and delivered, then the power of attorney is no longer effective. So when does the power of attorney otherwise terminate? Power of attorney will terminate when the principal dies. That's important because I have personally seen situations where an agent believes that they have the ability to continue to use the power of attorney and act on the principal's behalf even after the principal has passed away. Power of attorney immediately terminates upon the time that the principal dies. It also terminates when a principal becomes incapacitated if the power is not durable. We'll discuss durable powers of attorney in just a moment. It also terminates when the principal is adjudicated partially or totally incapacitated by a court. unless the court determines that certain authority granted by the power is going to continue to be exercisable. We'll discuss this issue shortly as well. Terminates when the principal revokes the power of attorney. Principal always has the ability to revoke a power of attorney so long as they remain capacitated. It's important that a principal consider filing the revocation of the power of attorney in the official records of the county in which he lives in order to give notice to third parties as well as the agent that the power of attorney is no longer valid. But under any circumstances, if the principal revokes the power of attorney is terminated. It is also terminated when the power of attorney provides for its own termination. As we mentioned earlier, if the power of attorney specifies that it's only valid for a certain period of time, for instance, a year, as soon as the year has expired, then the power of attorney terminates on its own. It will terminate when the purpose of the power of attorney has been accomplished. For instance, let's say that a power of attorney was given from a principal to an agent for the sole purpose of selling his car. The point in time where that car has been sold, the purpose of the power of attorney has been accomplished and it is no longer necessary, and at that point the power of attorney terminates. And lastly, it terminates when the agent's authority, the power of attorney, does not provide for another agent to act. So if the agent authority terminates and there is no succession plan under the power of attorney, then the power of attorney terminates. Now, I mentioned earlier durable powers of attorney. Well, what does it mean to be a durable power of attorney? Durable means that the power of attorney is not terminated by the principal's incapacity. So no matter what the principal's capacity is, the powers under that power of attorney will remain enforceable. A power of attorney is durable if it contains the words as specified in the statute. This durable power of attorney is not terminated by subsequent incapacity of the principal, except as provided in Chapter 709 Florida statutes, or if similar words to that are used in the power of attorney. Now, what if a judicial proceeding is initiated to determine capacity? What I'm asking here is if someone actually goes to the court to have the principal determined incapacitated. Well, once a judicial proceeding is initiated to determine the principal's capacity, or for the appointment of guardian, the authority granted under a power of attorney is suspended. Now, I know that is contrary to what the durable power of attorney says, but while this proceeding is pending, the durable power of attorneys is suspended until the petition for determination of incapacity is withdrawn or dismissed, or alternatively, the court has entered an order authorizing the agent to continue to act. Now, recently, the statute has been amended, and there is an exception to that prior rule. Now, even if a petition to determine incapacity or a petition to appoint guardian has been initiated with the court, if the principal has given the power of attorney to its parent, a spouse, a child, or a grandchild, then the authority to use the power of attorney will continue and will not be suspended throughout the term of the incapacity hearing pendency or through the pendency of the appointment of the guardian, unless a verified statement has also been filed to say that there is that the power of attorney is improper. Otherwise, throughout the pendency of the action, if the agent is a parent, spouse, child, or grandchild, the power of attorney will remain valid throughout the action. Now, what authority does an agent have under a power of attorney? It's important when you are looking at the document itself to look at what it says, because the agent is limited to the express powers listed in the power of attorney. As I mentioned earlier, it may say that the power of attorney is exclusively to give the agent the ability to sell the principal's automobile. Well, That's all that the agent is authorized to do under that power of attorney. That doesn't give them carte blanche to start writing checks off of the principal's bank account, or to be making gifts to the principal's children, or worse yet, to the agent's children. It is limited to what is written within the document itself. Now, that authority may include executing stock powers or other similar documents to register any stocks, bonds, or other securities into or out of the principal's name, or to convey or mortgage homestead property. What the agent may not do is perform any duties under contract that requires the specific exercise of personal services of the principal. It does not allow the agent to make an affidavit of the personal knowledge of the principal. It does not allow the agent to vote on the behalf of the principal. It does not allow the agent to create a will or revoke a will on behalf of the principal. It does not allow the agent to exercise powers of authority granted to the principal in the principal's capacity as a trustee or a court-appointed fiduciary. In other words, an agent cannot act on behalf of the principal when the principal enjoys his own fiduciary responsibilities. Now, what else is to look for in the power of attorney? A principal can give an agent broad authority to act under a power of attorney, but there are certain powers that must be specifically identified and separately signed or initialed by the principal. Now, if you're looking at the document, it is important to keep an eye on these different categories that you see here. If they are listed but not initialed or not signed specifically at each point, then the power of attorney does not grant the agent the ability to do these powers, such as create an inter vivos trust on behalf of the principal, amend, modify, revoke, or terminate a trust created by the principal. It does not allow the person to make gifts on behalf of the principal, or create or change rights of survivorship, create or change designations of beneficiaries, or waive the principal's right to be a beneficiary or a joint or survivor annuity, including benefits under retirement plans, nor does it give the power to disclaim property and powers of appointment, unless each one of these is specifically designated in the power of attorney and signed or initialed by the principal beside each one of these enumerated provisions. Now, what obligations does an agent have under a power of attorney? The most important thing for you to always keep in mind is that an agent is a fiduciary, which means that that agent owes a fiduciary obligation to the principal. The agent must act only within the scope of the authority granted in the power of attorney. If that agent goes outside of the power of attorney, he's breaching that fiduciary duty that he owes to the principal. Likewise, an agent must not act contrary to the principal's reasonable expectations actually known by the agent. The agent must act in good faith, must not act in a manner that is contrary to the principal's best interest, and must attempt to preserve the principal's estate plan as best as possible. Generally speaking, the agent is not authorized to delegate his power to a third person. The agent is also obligated to keep all records, receipts, disbursements, and transactions made on behalf of the principal at hand. The agent must keep an accurate inventory of any safe deposit box owned by the principal. The agent shall act loyally for the sole benefit of the principal. The agent shall not create a conflict of interest that impairs the agent's ability to act impartially in the principal's best interest. The agent shall act with care, competence, and diligence. And when requested, the agent shall produce an accounting of everything that they did using the power of attorney. The people that can request such an accounting are the principal himself, a court-appointed guardian, another fiduciary acting on behalf of the principal, or a governmental agency having authority to protect the welfare of the principal. Now, when you're looking at the document and you're considering each one of these issues, and to determine whether or not the fiduciary is acting in the best interests of if the agent is working in the best interests of the principal, and you come to determine that you believe that the agent is not acting in the best interests of the principal, what is the agent's potential liability for misuse? An agent who breaches their fiduciary obligation to the principal is liable to the principal for the principal or the principal's successors in interest for the amount required to restore the value of the principal's property to what it would have been had the violation not occurred, and to reimburse the principal or the principal's successors in interest for the attorney's fees and costs paid from the principal's funds or the agent's behalf in defense of the agent's actions. Again, here, if found liable, that agent is going to have to pay back everything that it misused in using that power of attorney, and is going to be on the hook to pay the attorney's fees and costs that were necessary to recoup those funds. Now, how is a court going to redress the issues concerning the power of attorney? Court has the authority under Chapter 709 to construe and enforce the power of attorney, to basically interpret what that power of attorney meant and what powers it gave the agent, to review what actions the agent actually took, to terminate that agent's authority under the power of attorney, to remove the agent as the fiduciary, or to grant any other appropriate relief that the court deems appropriate. Now, who's going to be entitled to ask the court for relief? The principal himself has the power to always ask the court for relief, to review, construe, interpret, and to consider the actions taken by the agent. A guardian, conservator, or trustee or other fiduciary acting on behalf of the principal may seek redress from the court. A person authorized to make healthcare decisions for the principal, any other interested person, if the person demonstrates to the court's satisfaction that the person is interested in the welfare of the principal and has a good faith belief that the intervention is necessary, a governmental agency having regulatory authority, or a person asked to honor the power of attorney may all ask the court to review, construe, and to act according to the power of attorney. Now, one of the main places where an agent is going to run amok with a power of attorney is where a conflict of interest may pop up. And the conflict of interest would pop up between the agent's best interests and the principal's best interests. As a fiduciary, the agent owes his primary duty to the principal. So if an agent's exercise of a power of attorney is challenged in a judicial proceeding on the basis that the exercise of the power of attorney was affected by a conflict of interest, and the evidence is presented that the agent had personal interest in the exercise of the power he used, then the agent is going to have the burden of proving by clear and convincing evidence that the agent acted in the sole interest of the beneficiary or in good faith in the principal's best interest, and the conflict of interest was expressly authorized by the power of attorney. Now, what this means is, unlike a normal situation where the agent may not have the burden of proving whether or not what they did was right or wrong, in this circumstance where there is a conflict of interest that is on its face, the agent is going to have the burden of proof to prove to a court that it did not have a conflict of interest that affected what it was doing because it was expressly provided for within the terms of the power of attorney, and that he acted in the sole interests of the principal over his own interests. Now, aside from the remedies that are provided in 709, which we have just gone through, to consider and review the terms of the power of attorney, to review how the power of attorney was used by the agent and whether or not it was misused, and the damages that could be recouped in that situation, be it the monies that were stolen or misused or misappropriated, and the attorney's fees that were used to have to recoup those. There are other avenues for redress when a power of attorney has been abused. And you should look to section 415.102 of the Florida statutes and section 825.103 of the Florida statutes. Chapter 415 is the Adult Protective Services chapter of the Florida statutes. And in that section, it is dealing with exploitation of a vulnerable adult. Chapter 825 is dealing with criminal statutes. And as a criminal statute, it is dealing with exploitation of the elderly person or a disabled adult. In each one of these situations, it considers the misuse of a power of attorney as a violation of these statutes and evidence of exploitation. Specifically in Chapter 415, it defines exploitation as a person who stands in a position of trust or confidence with the vulnerable adult and knowingly, by deception or intimidation, obtains or uses the property of the vulnerable adult and uses it to their own benefit. Or that they know or should have known that the vulnerable adult lacked the capacity to consent to the use of their assets. And in doing so, they have section 8B, where it says exploitation may include, but is not limited to, breaches of fiduciary duty, such as the misuse of a power of attorney or the abuse of guardianship duties resulting in an unauthorized appropriation, sale, or transfer of property. Similar to what it says under 709, in this situation, it would be the agent using the power of attorney for his own benefit over the interests of the principal. And in this situation, that would amount to exploitation. It is very important when you look at this chapter that you see that the principal has the ability to go after and pursue damages under Chapter 415 when they have been the victim of exploitation as a result of the misuse of the power of attorney. And under that chapter, it does provide for punitive damages. It also provides for the recoupment of attorney's fees. Chapter 825, as we discussed, is a criminal statute. Similarly, this statute deals with the exploitation of an elderly person or a disabled adult. And like Chapter 415, it also specifies that a breach of a fiduciary duty under the misuse of a power of attorney is going to be considered a violation of this chapter and would be considered exploitation of this criminal statute. As a result, the Florida legislature has also created a presumption in a circumstance where that power of attorney may have been misused under the criminal statute. Under this section, any inter vivos transfers of money or property valued in excess of $10,000 at the time of the transfer, whether in a single transaction or multiple transactions by a person of 65 or older to a non-relative whom the transferor knew for less than two years, it's going to be presumed that that was a situation of exploitation. So when you're looking at your power of attorney and you're looking at how the power of attorney may have been used, and you see that the agent and the principal have only known each other for about 2 years or less, and that the agent is taking funds in excess of $10,000 for their own benefit or for someone's benefit other than the principal and against the principal's best interest, this statute creates a presumption against the agent in favor of the principal that there is exploitation. Under this circumstance, that agent could be subject to criminal prosecution and criminal punishment. In short, the Florida statutes under 709, 825, 415, and other statutes that are available out there provide many protections for a principal who may be being abused by the use of a power of attorney. And it is important for you, when looking at the power of attorney, to see whether or not such abuse might be taking place. And this is an overview of those considerations that you need to be looking at when you are asked to review a power of attorney for the first time. Ask to see the power of attorney. Actually put hands to the document, put your eyes to it, read through the document, and see what it says. First and foremost, look to see whether or not that document was executed properly. Does it have the signature of the principal on it? Does it have 2 other witnesses on it? Does it have a notary's signature? Is it in writing? Look to see what the power of attorney actually says. What does it provide? What powers does it provide to the agent to perform? Remember, the agent is only allowed to do what is said in the actual document. Look to see whether or not the power of attorney has been revoked by any subsequent power of attorney or some other writing. Perhaps go to the official records of the county that the principal is living in to see whether or not any revocations of the power of attorney are of record. Look to see whether or not that power of attorney that has been provided has limitations of its own within the writing. Does it say that it is only specified for a certain term? 1 year, 2 years? Does it say that it's only valid for the power of exercising one specific transaction, and has that transaction actually been completed? If so, the power of attorney may have been revoked or has already been terminated. Look to see whether or not the power of attorney has the language in it, as we reviewed earlier, that makes it a durable power of attorney. If not, is the principal incapacitated? If the principal is incapacitated and the power of attorney is not durable, then that power of attorney may already be terminated as a result. If it is durable, has any judicial proceeding been initiated to review the validity of, or to determine whether or not the principal has lacked capacity or is in need of a guardian? If so, and that proceeding is pending, does that proceeding have any effect upon the validity of the pending power of attorney? If it is not the spouse, the parent, the child, or the grandchild, the existence of that proceeding all by itself may mean that that power of attorney is suspended during the pendency of those proceedings. For that matter, look at what the relationship is between the principal and the agent. Are they family? Because if they're family, then that power of attorney may remain valid even during the pendency of a proceeding. If they're not family, and there is the potential that they are recently met, that may mean that there is presumptions to the fact that this power of attorney is being abused by the agent, and that the agent is not acting in the best interest of the principal, at which point there may be a presumption of criminal liability. What specific powers are granted to the agent and what limitations? What transactions has the agent performed? Now remember, again, there are certain very important powers that can be given to an agent under a power of attorney. Those being the ability to give gifts, to make trusts, to revoke trusts, to amend trusts, to deal with the principal's assets in a way that could be very detrimental to the principal if misused. Remember, if those powers are granted in a power of attorney, they have to be listed specifically and signed off specifically by the principal. Look to see if the power of attorney provides for that. Then consider what actions the agent has actually performed on behalf of the power of attorney. Perhaps go to see whether you can get an accounting from the agent to look at the different transactions. Look to see whether or not there has been any conflict of interest between the agent's interests and the principal's interests. Are monies being used to benefit primarily the agent to the detriment of the principal? And if there are such conflicts of interest, do they rise to the level of being a breach of the fiduciary duty of the agent such that there can be damages and relief through the courts? And if there is the need for that, remember what those potential avenues of relief are. Remember the avenues of relief to recoup the funds that were taken under Chapter 709. Remember that you have the potential relief under Chapter 415 if the principal is a vulnerable adult under that statute. Remember that you have the potential remedy under Chapter 825 on the criminal statute if the principal is an elderly person that is being victimized by the misuse of the power of attorney. In short, it's very important to just look at the document itself and to consider what the document says. If at any point you've got a question, go back to Chapter 709 and take a look at it. Read the actual language of the statute and keep in mind what, if anything, that agent may be doing to misuse the power. Just because an agent shows you a document and tells you that they have the authority to do something does not mean that they actually have that authority. It is important to keep all of these aspects in mind when reviewing the viability of a power of attorney and the actions that are being taken by the agent. I thank you for your time today and hope that as this has been helpful to you all.